Hello, everyone. Good evening. My name is Gregory Countess. I am the Director of Advocacy for Housing and Community Economic Development for the Maryland Legal Aid Bureau, also known as Maryland Legal Aid. And I'd like to welcome you to the Attorney General's COVID-19 Access to Justice Task Force Town Hall. And this particular presentation is on preventing eviction in the age of COVID-19. And I'd like to take this opportunity to introduce to you all the sponsor of this particular presentation, the Attorney General for the state of Maryland, Mr. Brian Frosh.
Thanks very much, Greg. First, really appreciate the work that you and your colleagues in legal aid are doing, and very much appreciate your willingness to come give this presentation tonight. Early in the COVID-19 pandemic, we recognized that it was going to be more than just a health challenge. We knew that the resulting economic impact would create significant hardships that only the civil justice system could resolve. So we have examples of missed rent payments leading to eviction, disputes over medical and consumer debt, people who are wrongly denied access to public benefits that are necessary to keep their families housed and fed. And today, many of our neighbors are left with the significant challenge of navigating the post-COVID civil justice landscape. And this task force was created to identify short-term and long-term civil legal issues that many of our neighbors are confronting. And the most time-sensitive of those is the housing and eviction crises that families are facing. With Marylanders looking at job loss or loss of income, we expect an avalanche, a tsunami, whatever you want to call it, of eviction proceedings over the next few months. This town hall is designed to help provide those who are facing these problems with useful information on how to navigate the court process and how to find the resources that are available to keep them and their families afloat and safe. So I want to thank everybody who's serving on the task force. I want to thank the Maryland Bar Association for being our partner in this process. And I want to thank again Maryland Legal Aid, Greg Countess and his team for their great work and for the information they're about to give you. So again, Greg, many thanks. Take it away. I think you may be on mute.
All right. Sorry, folks. As you can see, I'm rather elderly, and I don't adjust to this particular world very well. But I'll get there if you bear with me. Again, we'd like to thank the Attorney General and the Maryland State Bar Association for their efforts and sponsoring this and helping us to bring what we hope will be information that you can actually use. But to use this information, we want to emphasize something that a theme that we emphasized in the first town hall, and that is this presentation will provide you with some specific defenses that are related to or COVID-19 related. Defenses that were not available pre this pandemic, and when the when the state of emergency ends, they will not be available to you at that time. And so in order to use these defenses, it's very important that you go to court and that you also take the opportunity to consult those legal resources, which we will be directing you to at the end of this presentation, to ask any questions you have that will be particularly apt for your own personal issues and concerns. And so with that, let us begin. The two presentators that we have today are Douglas Nivens with the Maryland Legal Aid and Daniel Rosenberg. Doug?
Thank you very much. So I'll be covering the first section here, talking about the CDC evictions order. This information, as Greg said earlier, is available during the current situation with the pandemic. The Centers for Disease Control and Prevention issued this order in early September, and is effective through at least currently the end of this calendar year, so December 31st. In summary, it allows a tenant who, with certain eligibility, most likely for those who are low income, who do not have the financial means to pay rent, able to assert this as a defense to prevent an eviction. Now, the order is focused on landlords who have a right to evict tenants, especially those for non-payment of rent. It does not include foreclosure on a home mortgage. The order is also supposed to be secondary to any other eviction moratorium and provide greater protections, which my colleague Dan Rosenberg will talk more at length regarding the governor's order. But in short, it's a way in which a tenant can at least inform the landlord that they can, when they're able, pay their rent, but in the meantime, still maintain their place to stay. It also, as a big important caveat, it doesn't take away the duty to pay rent. It is only a means to stop an eviction. So we go to the next slide. We're going to go talk more about the actual declaration. Part of this is the act itself is for the tenant to give a declaration, to do so under penalties of perjury, in which a tenant said that the tenant will be using their best efforts to obtain all available government assistance for rent or housing, that they are limited income. So in this instance, we're talking about an individual who make less than $99,000 a year or $198,000 for a joint filing couple, or for those of you who may have received an economic impact statement or stimulus check, you will also be able to qualify. And you'll make this statement that tells the landlord that you can't pay rent due to a substantial loss of income, your loss of work, you were laid off, or there's some extraordinary out-of-pocket medical expenses, that you're going to use your best efforts to pay rent as much to the full amount when one has the means to do so, and that the tenant has no other housing option. So, but for the financial situation presented here, the tenant is facing imminent homelessness, or may have to be in a place where they have to share a home with another group of people, thereby exposing them to the risk of a COVID-19 infection. And of course, lastly, that the tenant will understand that this temporary halt on an eviction may end on December 31st. At least that's what we know as of right now. The copy of the declaration form is available online. One may, you see the web address is provided by the CDC website. One thing to keep note is that if a tenant is in a situation where a landlord has filed a complaint in district court, this declaration may be a means to assert that defense and have it at least recognized by the court. So we go to the next slide here. We can talk a little more in depth about the process in the district court. So according to the latest communication from the judiciary, it is currently being treated as an affirmative defense. Most commonly, we'll see this in a failure to pay rent case. For some of you, that you may hear it as rent court. But at that situation, a tenant may present the declaration as a defense. The court may ask the tenant to provide more information about do they qualify, or they meet the income eligibility requirements, and if so, then the court is supposed to make a finding over how much rent is due and owing, and at that point will reserve judgment until such time the CDC order is not enforced. So what they may look like is that while the court will say that a tenant may owe a certain amount of money, that the court will not issue a judgment, thereby allowing the landlord to file a warrant and actually carry out an eviction. So for many people, this would be an opportunity for the tenant, if they're able to get the financial means, to help pay down whatever the alleged amount owed for rent. But it's also, there's a responsibility for the landlord to inform the court of when the amount owed has changed. So if, for example, an amount of money may be owed, but it's not the same amount that was owed at trial, but maybe some lower amount come January 1, the landlord is supposed to inform the court what that amount is, so that when judgment is actually formally entered, it'll be at the appropriate amount that's actually due and owing. Now, as many of you know, we are in a situation where things are in flux. The CDC order is currently through December 31st. We don't know, but if that may change, hopefully we will hear more about that from the CDC once we get closer in December. All right.
All right, so my name's Dan Rosenberg. I'm a colleague of Mr. Nivens here at Legal Aid. And what I'm going to go over is, in addition to the CDC order, there's also a order that Governor Hogan put out on March 16, 2020. The number of the order is 20040301, which deals with residential and commercial evictions. For this purposes of this conversation, we'll just be talking about as it pertains to residential evictions. It is in effect March 16, 2020, and is in place until the state of emergency is terminated and the catastrophic health emergency is rescinded. The state of emergency was renewed as of September 8th, 2020, so the order is still in effect. This order applies both to failure to pay rent cases, which are filed under Section 8401 of the Real Property Article, and breach of lease cases, which are filed under Section 8402.1 of the Real Property Article. Much like Mr. Nivens explained with the CDC order, these defenses, this order does require the tenant to go to court to raise the defense. It's not something where you can simply inform your landlord about a certain thing and to prevent a filing. It's something that requires the tenant to go to court. And additionally and importantly, like the CDC order, it does not relieve the tenant of rent payment obligation or prevent eviction after the state of emergency ends. So with that, can we please go to the next slide? So just because I'm an attorney, I always like to give the very intimidating looking text of the order, just so it's clear what this is in reference to. And what the order states is that no court shall give any judgment for possession or repossession or warrant of restitution of possession or repossession of residential, commercial, or industrial real property if the tenant can demonstrate to the court through documentation or other objectively verifiable means that the tenant suffered a substantial loss of income. So the question then becomes, what's a substantial loss of income? Well, that's also defined in the order, and that's defined as, with respect to an individual, a substantial loss of income resulting from COVID-19 or the related proclamation of a state of emergency and catastrophic health emergency, including without limitation due to job loss, reduction in compensated hours of work, closure of employment, or the need to miss work to care for a homebound school-aged child. So this is for failure to pay rent cases. Now, if we can go to the next slide, you'll see that the language for breach of lease is very similar in that again, it has the no court shall give any judgment language. This is the same both for rent and for breach of lease cases. Importantly, the provisions alter the breach of lease to state that you cannot be found to have breached your lease simply because you have COVID or are suspected to have had COVID. And that's what that says there. The fact that the tenant or any person permissibly cohabitating with the tenant in accordance with the terms of the lease has a confirmed diagnosis of COVID or is under investigation of COVID shall not constitute a clear and imminent danger for the purposes of that very long series of numbers and letters that constitute that part of the breach of lease law. So what that means is that when the statute says that you could be evicted for something that's a clear and imminent danger, COVID or suspicion of COVID for a tenant or legitimate occupant, we can get into a little bit about what that means, is not going to be grounds for a breach of lease in this instance. So that's the kind of very thick technical part of it, and we can go to the next slide. I just kind of want to break down kind of what this means going forward. So how to prepare for court and what to do with these defenses. Number one, as Greg said, and as I'm sure Douglas will say, and I'll say probably about 20 more times before this is over, call a legal services provider for advice and potential representation as soon as you receive a breach of lease, termination notice from your landlord, or if you receive a summons. Time is of the essence. Do not delay in contacting legal service provider, and have your documents ready when you contact them so you can have a discussion about it. That's the number one thing, because these can be kind of factually intensive investigations. Second, if you have suffered a substantial loss of income, gather whatever records you may have to show this. As you'll recall, the order says through documentation or other objectively verifiable means, so it doesn't have to be an official termination letter where your employer says, I'm reducing your hours or I'm letting you go due to COVID. It can constitute anything that's thought of as objectively verifiable. This can mean screenshots of text messages from your employer, termination letters or emails. If you don't have any documentation, what you can do is contact your former employer and ask for a letter confirming that you were let go, the date of that, and that it was due to COVID or the related economic slowdown. Finally, if you have a school-age child, bring something that confirms that they are homebound and school-age. A birth certificate is great for this. I imagine some documentation from their school confirming that they're an enrolled student would be helpful for that. So really what it is it's incumbent on the tenant to show that they have suffered either this substantial economic loss or the homebound school-age child, and whatever documentation that you can have to corroborate that is essential to raising this defense. And then going to the next slide, we're kind of going to talk about a little bit about how the district courts have said they're going to be interpreting this, and this is from two orders from the Chief Judge of the District Court, Judge Morrissey. And again, I'll just read the thick legal jargon and then kind of break it down. If this defense is raised, it will be treated as an affirmative defense in both failure to pay rent cases and breach of lease actions until the governor's state of emergency is lifted or the executive order is amended. Each judge will determine the sufficiency of the evidence provided. Now, what that means is that, again, you have to go to court to raise this. Again, it can't be something where you simply send a letter to the landlord, send a letter to the court. You have to be there to present the evidence that you qualify for this defense. Additionally, each judge making the determination means that the judge will have to make a determination that the documentation you have provided, or the information you have given, is sufficient to raise that defense, to meet the burden of having raised that defense. Second part, if a tenant is successful in asserting this defense, the court will determine the merits of the case and or the amount that is due. So the merits of the case, meaning for a breach of lease case, and the amount that is due for a rent case, but will reserve entry of judgment until such time as the judgment is not prohibited by the governor's executive order upon termination of the state of emergency, or upon the rescission of the health emergency or applicable action by the governor. The court, without request for any party, will enter judgment for possession that was reserved by the court. The landlord, much like a CDC order, has a continuing duty to inform the court of any payments made by the tenant while the case is pending or reserved. So if this is something, and we'll get to this, where subsequent payments are made, your landlord has an obligation to inform the court about this. And what this means is that a judgment is not formally entered if you raise this defense. Rather, the court will conduct some kind of fact finding to determine the merits of the landlord's case. If they find that under normal circumstances it would entitle the landlord to possession, what they will do is reserve an entry of judgment but make factual findings. And once the state of emergency is ended and the order is rescinded, that judgment becomes entered automatically. You would not get a new court date, you would not get a new hearing. That would simply, as a matter of law, get entered. So if we can go to the next slide, and this is kind of redundant on what I just said, but what this means is the court will determine how much you owe, and a judgment which may lead to an eviction will be entered automatically once the emergency is lifted. So again, raising the governor's order related defense will not push down the road any discussion about what any rent is owed. It will be a determination will be made at that time, and then that judgment will not be entered and will not be actionable until the state of emergency is lifted. Ditto too for breach of lease cases. There will be some factual determinations made. If the court determines that under normal circumstances they would enter a judgment for possession for the landlord, meaning an eviction judgment, that would then be withheld and then automatically put in place once the order is lifted. So again, just to circle back for this reason, contact a legal services organization as soon as you receive your summonses to determine if you may have other defenses, because just because you are entitled to this defense doesn't mean necessarily it's the best course of action. And that's why people like, us at Legal Aid and other services organizations, kind of are, really exist to help. Is you may have defenses where the landlord's not entitled to the rent, or there are other mitigating factors in a breach of lease case or something like that. You don't want to get yourself in a position where you're agreeing to a reserved judgment when you may have defenses to simply, knock that case out of there. And that's why, again, we're going to get to the resource how to contact us. That's really what you want to do. As soon as you get anything from your landlord in writing or a summons, contact some legal service organization to go over that. So with that, I think I'm going to be turning back over to Douglas for some other material about housing quality.
All right. So for this last section here, we're going to talk about the dealing with conditions in your property. We understand that there are many people for whom have been living in different property, and due to the pandemic, they haven't been able to get the appropriate repairs in the property. Some landlords aren't getting rent, therefore they're not spending the resources to abate different type of threat that may be in those properties. So there are a few different options available for those in that situation. Just because you may not be able to pay, it doesn't necessarily excuse the landlord's obligation to give you a place that is habitable, or a place that's safe from danger to your life, health, and safety. So first thing first is, if there are conditions where you live, there are a threat to you or any other person in the premises, life, health, and safety, then you need to notify the landlord, preferably in writing. If you want to, by all means, do by mail, certified mail, if you want to have a receipt to show that that person, so show that you appropriately notify in writing what is going on in the property. Definitely take pictures and photos of it to document what are the conditions. Alternatively, depending upon where you live, you may be able to contact your local health or housing department for a property inspection. So for many of us who practice in Baltimore City, that's calling 311. But for depending upon where you are, those departments may be able to also send an inspector to the property to check out what are the conditions there, they rise to a code violation, and to also notify the landlord that this is an issue that needs to be corrected and a timetable to get that corrected. If after notice has been given to the landlord and no work has been done in a rent escrow situation that is presumed to be at 30 days to fix those problems, then the tenant may pursue a rent escrow action. It's a situation where essentially the tenant sues the landlord, or telling the court, essentially, I'd rather pay my rent to the courthouse than to my landlord, to entice the landlord to actually fix the premises. That is a very high overview of what that process entails. And we'll go a little bit more in depth about that issue here. And let's go to the next slide, talk about the rent escrow process. The tenants are the plaintiffs in this situation. It's a means in which a tenant may withhold rent without being penalized. It's a way in which to get the court to actually enforce the landlord to make the repairs to the property, or depending upon the severity of the situation, maybe even terminate the lease. The process entails very similar to what I said before earlier. A tenant files a complaint in court. An inspector goes to the property to check out the premises. For many places, that inspector comes from the same housing department that would do any other property maintenance, maybe just in a different unit. At trial, it'll be the tenant, the landlord, and inspector. Everybody will be testifying to the court about what's going on the property. The inspector will give a report about the conditions that they found, and the judge will have to make a determination about whether or not they rise to a level of a threat to life, health, and safety. If a court finds that there is a threat there, then the court may open an escrow account whereby the tenant will pay into that court their rent. This may include back rent. So for many people who are thinking about doing rent escrow, if there is several months of rent unpaid, the court could ask, or could actually order, the tenant to put all that back rent into the escrow account to continue the case. If a court orders an escrow to be paid and it's not paid, then it's going to be an automatic dismissal. So one thing to keep in mind about rent escrow is that it is not a way to not pay rent just because you can't afford rent. Rent escrow is a means to not paying rent due to the conditions, whereby you're asking the court to receive your rent payments instead of the landlord. Now, Depending upon the circumstances, a rent escrow could be raised as an independent lawsuit or affirmative. So tenant goes right out and sue the landlord, or it could be raised as a defense in a rent court action. So depending upon what's going on in that particular person's situation, some people may find best to raise it as a defense, whereby then the court will consolidate a rent court case with a rent escrow case, and it begins there on the next court date, again, going out with the inspector, make a determination what are the conditions thereof, and then the court will make a determination about whether or not to open an escrow account. Now, in the next slide, we'll talk more about the remedies, and that's coming up in the next slide. So here's just an example of some of the ways in which the court can actually help the tenant if the court finds that there are threats there. And again, these are just listed examples. The court does have some broad authority over how to ameliorate the situation. First and foremost, to direct the landlord to make the repair. That is why we're in rent escrow in the first place. And again, the opportunity to pay rent into the court. If that is the decision made, the court will determine how much is paid, at what time and interval to make those payments, even to reduce the amount of rent. So for example, a judge may say, hey, we're going to set your rent 0 at this month and maybe some other amount a later month. A lot depends upon the severity of the conditions and the loss in value between the property as you expected versus the property with the conditions. The court can find actual damages for breach of warranty or habitability. The court can terminate the lease if that is what the tenant wishes to do. It could appoint another party to make repairs and pay for those repairs from the escrow account. So say, for example, there's no trust with the landlord to do the repairs, and that the tenant has found somebody who's competent enough to do the work and maybe do it better and more efficiently, then with permission of the court, that rent money can go to that person to do those repairs. And again, if we're in a situation where, say, the property is facing foreclosure, then the landlord the court may mandate payment from the escrow account to go towards the mortgage so that there'll be no foreclosure. Just to reiterate again, when it comes to these housing quality issues, be sure to put in writing what are the conditions you're facing with the landlord so that they have notice and you have record that you made them aware of the conditions. And then from then you can also, again, contact your local health or housing department about those issues to have an inspection done. And if it applies, you may pursue rent escrow claim either as an independent suit or as a defense in a rent court action. All right, and that brings us over to the last few slides that we have here, beginning with legal resources. Greg, would you like to go over those, or are we just not sure how we wish to cover them?
Thank you very much, Douglas. So let me tell you that you don't have to jot all of these down because they may, I guess we'll leave them up on the screen, but you'll be able to have access to this PowerPoint and to the presentation itself. If you go to the Attorney General's website, and if you look under the Attorney General's COVID-19 Access to Justice Task Force, and under the under the heading Resources for the Public, you'll see community forums. That's both in English and in Spanish. And I would direct you there. You'll be able to look at this presentation again. And I believe you'll be able to access the PowerPoint itself. And so at this point, we want to ask questions. And I think that one of the questions I'm going to ask is of the panelists, and either one of you can choose to answer. Are evictions halted now? Is there an eviction moratorium?
No, evictions are going on, and they've been going on since actually August, at least in the city. Now, It depends upon the type of eviction. So many people are going through eviction due to tenant going over, wrongful retainers, certain breach of leases that were found earlier in the year, but evictions are going on. So right now, the CDC order, came into place on September 4th with those who, in that situation where maybe an eviction is pending and they qualify for the CDC order, for example, then in that situation, the tenant, by all means, should be able to give their landlord the declaration saying that if the cause of the eviction, especially if the cause of the eviction is due to non-payment of rent, that they should be able to file the declaration, give it to the landlord, but they're also going to have to file a motion with the court. So in that situation, I would definitely say one should seek out legal assistance, because that can be a fairly, could be a complicated process. Once an eviction has been granted, it takes the court to cancel it, unless the landlord wants to voluntarily do it. But by all means, evictions are happening. They are occurring in all these jurisdictions here, and without some other action to the contrary, they will continue happening.
And so, Douglas and Dan, I guess that's why, again, and I'll say this again, please go to court. Now, we have a question that's been asked, and it says, there's a percentage of the population that has been trained not to go to court and wait for the letter from the court with a judgment. They then take the letter to churches and agencies for help. Can you tell the audience why, in fact, that may not be a good idea?
Sure. So number one is that if you don't go to court, you don't have any control or influence over what the judgment may be. And in almost all likelihood, a judgment will be entered against you, a judgment which could lead to an eviction if, first of all, if the kind of presumed safety net doesn't exist at that instance, but also you're not giving yourself the opportunity to present any defenses that may exist. Simply laying back and allowing the judgment to happen to you, in Baltimore City, there's an awful lot of defenses that exist, both in terms of the conditions, like Mr. Nivens talked about, but also having to do with, making sure the landlord is complying with all the local regulations. So the number one most important thing that can come out of going to court is you ensure that your side is told to the judge. If you don't go, no one will do that. And relying on simply saying, I'll allow this judgment to happen and then get financial assistance is a very dangerous game if that assistance doesn't come through. And also you're shortchanging yourself with the ability for defenses where you might not even need that assist. You would have other defenses. And that's why, again, I think what the number one thing you should do is if you get a court paper or a notification from your landlord that they intend to terminate your lease, call a legal services organization. Talk through it with somebody who's been there before and can talk you through not only what options you have, but also what defenses you might have. That's the number one most important thing whenever you get something from the court or from your landlord like that.
And I want to add to that is that when you were talking about going to different churches and agencies for financial assistance here, we are in a recession, and many of the same places that people will rely upon for the financial assistance may not be able to find that assistance available because there's been such a high demand for financial help when it comes to housing. So again, as my colleague said earlier, it's up to, by all means, you're the tenant, if you're being told you have someone to go to court, you need to go to court. Make sure that the amount that's due on it is actually the correct amount. Because once the judgment is entered, it is a lot harder to try to undo that, especially if one had a chance to go and didn't. So by all means, one should definitely go to court. Even if a judgment may be entered, one should at least get a copy of that judgment for their own records to know what it's actually doing on. Just because, as we said before, under the current instructions from the judiciary, the landlord is supposed to notify the court if there's any changes in the amount due and owing. So if the tenant has been making payments, but that is not told to the court, then a warrant may be issued come January for a higher amount than what the tenant may expect. So by all means, one should definitely, go to court, keep your proper documentation, If you're going to start making payments of rent, make sure you have a receipt. If one does not even give you a receipt, make your own receipt. But no money should leave out your hands without some type of paper trail following it. So very good question.
The next question is, will landlords be able to raise your rent if your first lease ends and the renewal begins? I believe this question is referring to if that occurs during the state of emergency.
Sure. So I'll take that. Again, the certain municipalities throughout the state have passed. I know Baltimore City has certain prohibitions on rent increase during the state of emergency. Barring that, rent increases are always statutorily regulated and are regulated by what the lease states and how much notice can be given. In an instance like this, where the landlord is either saying that they're going to not renew your lease or offer a new lease or raise your rent, again, this is an instance where it's very incumbent upon you to, as soon as you get that notice, to contact a legal services organization with your lease and with the notice to confirm that it goes along with whatever with the relevant statutory process. Again, speaking in Baltimore City, there is a current prohibition on rent increases for leases that expire during the state of emergency. I shouldn't say pandemic, during the state of emergency. Statewide, again, it varies county to county and jurisdiction to jurisdiction as to what that timeline is. And that's why if you do get a notice like that, contact a legal services organization in your community so you can get the appropriate advice for that timeline.
Sorry. The next question that's asked is, landlords sometimes use the term vacate the premises instead of eviction. What does that mean?
So there's a couple ways to look at this. Just to look at just the pure terms themselves. So there are situations where a landlord may issue a notice to vacate to a tenant. We see this often in a setup to a breach of lease action or a tenant holding over action. And that notice to vacate is to, as the name implies, supposed to inform the tenant that the lease is going to end. In a tenant holding over, it means that the lease is about to come to its natural conclusion, and the landlord is giving notice that at the end of that, when that end date arrives, there's an expectation that the tenant will leave. So most commonly, for many people who are in, say, a month-to-month lease, for many jurisdictions, that's a 30 days notice. I know in Baltimore City, it's 60 days. Or if in a breach of lease situation, the tenant, if the landlord is alleging that the tenant did some type of act that is substantial enough that even to warrant a breach of lease action, then the landlord still have to give notice to the tenant that they're ending that lease for that particular reason. That's very different from an eviction. An eviction is the judicial process of removing a person from the premises. So a landlord can only evict a person with a court order. You have to go to court, a judge got to okay it, and then they have to get a warrant, and it had that warrant issued from the court, transmitted to the sheriff, and the sheriff oversees the actual removal of the person from the property. Now, if the landlord is confusing the terms together, one should just look at what is the landlord trying to convey. The landlord saying, I'm going to evict you and you got to leave, by tomorrow if you don't pay rent. Well, that's quite frankly illegal. And the best thing we want out of you from this situation, at least from this presentation, is to know that, hey, if your landlord is trying to do something that doesn't seem quite right, I would say very often to please trust your instincts and contact a legal professional who can go through those facts and see, okay, what is really going on here? Are people following the right rules under the statutes? And if not, what options are available?
Right, and if I can just to echo what Douglas was saying there, If you do get a notice to vacate, as soon as you receive that notice to vacate is when you call a legal services provider. The general rule is that, rather, the general way I think about it, I should say, is that if it doesn't say why, it's something that could lead to a tenant holdover, which is sort of your lease has come to its natural conclusion. We'd like to repossess the property. If it gives specific reasons why they're doing so, it tends towards what I think of as a breach of lease case. Nonetheless, notices can be a little vague or unclear, and it can even be unclear what kind of action the landlord intends to take after that. And that's why, again, as soon as you receive that kind of notice, you should really contact a legal services organization for assistance. This is doubly true if you have any kind of subsidized housing assistance where, managing that move or seeing what other additional rights and protections you may have. The earlier you do that, is very much to your advantage. So again, certainly we know from the governor's order that failure to pay rent cases and breach of lease cases are explicitly governed by it. Tenant holdover cases are not explicitly governed by it. That is, certainly if it's something that happens, you contact a legal service organizations. They can talk you through the process and what other arguments and defenses you may have.
So for follow up to that particular question, and I'm going to ask you guys to sort of read between the lines, is can a landlord use a notice to vacate to get around all of this with a halt of evictions? With the halt that is in evictions, I guess, for coming from the potential halt because of the governor's order or the CDC order?
Okay. I would say that if you're in a situation where a landlord if you're a tenant and the landlord's given you a notice to vacate, and the reason being because the landlord is trying to evict you, the landlord can't go to rent court, so they're using some other way to remove you from the premises. One, definitely call a lawyer. And two, I would say that from what we understand, an argument can be made that no, the landlord will still have to abide by the CDC guidelines. Now, like I said, this is an ever-changing legal environment, and every case is different. Every trial is different, and every judge is going to be different. And so, in order to make a sound argument and present a defense, one should definitely talk to a lawyer to assist them in that, because there may be there's a certain strategy that one may need to pursue, but also it depends upon the facts that you have. As of right now, we know under the governor's order, one cannot be removed for non-payment of rent or for breach of leases if so is connected with the COVID-19 pandemic. And I would say by all means, again, one should definitely talk to a lawyer about that and should have, gather in preparation for the discussion, gather whatever evidence one has about the reasons surrounding the landlord trying to remove them.
So suffice it to say, Douglas, I guess what you're saying is that let the judge decide.
Absolutely.
All right. A question I'm gonna follow up. This is another question that's asked along that same line. If someone receives a notice to vacate, is it gonna help them out if they fill out the declaration form?
Sure. So just to confirm, when we're saying notice to vacate here, we mean the lease term is over, we desire to repossess the property. We're not talking about a notice of lease termination, like a breach of lease context. We're talking about a potential tenant holdover case. Certainly, I think in determining whether it would be beneficial to fill out the declaration, contact a legal services provider. But as Mr. Nivens was explaining, as we kind of concluded the previous question with, If it's something where you believe that this is due to economic loss, and it hints towards being covered at least implicitly or thematically by the CDC order, that is something that, with the conjunction with an attorney's advice about the specifics of the situation, may well be a good course of action.
Here's a question. Is there a maximum amount of back rent the landlord can collect?
So I would say that there's a 3-year statute of limitations for most civil actions in Maryland. So now that I would think quite irregular if a tenant has 3 years of back rent that's owed. But in general, no, there's not necessarily a maximum amount. Now, there may be some situations where that may apply. So for example, in Baltimore City, effective January 1, 2019, there was a licensing law that came into effect that says that landlord must have a license to collect rent for most non-owner occupied properties, and also excluding the housing authority of Baltimore City properties. So that could be a situation where you may actually do have a limit. It depends upon the facts, but in general, no, there's not a maximum limit. That's not like, there's not a maximum threshold, like, no, you can't collect at that point.
And also, if I can just add, that's certainly true in the fair to pay rent eviction context. If we're talking about a civil action collections case, which I know is not the purview of this presentation specifically, but in that case, there has been recent Maryland Court of Appeals law that leases are not contracts under seal, cannot be contracts under seal. Contracts under seal can open you up to this 14-year statute of limitations. They are governed by the 3-year statute of limitations, for collections cases. So I know that's different than rent cases. That's just something to add as well.
All right. Now, there's a question, I guess, that's asked about how do you ensure, I guess, that if you were to use the CDC order as the district court currently applies it, does the landlord have to agree to abide by the declaration? Or that is, do they have to agree not to evict pending the lifting of the reservation of judgment and the entering of that judgment?
So if I'm understanding the question correctly, it's while judgment is being reserved by the court, can you be physically evicted by the sheriff? And with a few caveats I'll get to at the end, the answer is no. You can't be evicted until there is a judgment entered against you in court. And the way that the district court is interpreting both of these orders is that they are reservations of judgment. Judgment is not entered until that time. So until that there's the end of if it's the governor's order or the CDC order, until there's the end of that coverage period, a judgment is not entered, and an eviction cannot proceed until that judgment is entered, because in Maryland, the order for evictions goes, a judgment is entered. Sometime later, the landlord gets what's called a warrant of restitution. And the warrant of restitution is a document that entitles them to go to the local sheriff or constable and schedule an eviction. So the way that it prevents a landlord from evicting, and evicting meaning physically barring entry from the property and turning over the property back to the landlord and retaking possession, is that the landlord would not have an actionable judgment to carry out that eviction. That being said, there could be collateral, they could reserve judgment on the rent case and then try to take another action, which may be quicker. And that's, again, something where, because of this complexity of the situation, if that sort of thing happens, that's when you call, Maryland Legal Aid, Public Justice Center, whoever is on the list of legal resources for consultation on that.
All right. If I can flip to this a little bit, if you can move the slide to the next slide. It has legal resources at top, and I think we want to show you, if we can, the list of rental assistance resources. It was a question that asked whether or not there are funds for mortgages. That goes beyond the scope of this particular presentation, but we will not ignore that question. We will direct it to the relevant persons. so that you can get that answer. In the meantime, you may want to dial 211. The operators at 211 may be able to answer the question of whether or not there's mortgage assistance available. You may also want to contact these legal providers, including legal aid. There's another unit in legal aid that handles mortgage foreclosure issues, and there may be other relief that may be available to you. Now, it says, what are the penalties? The next question, what are the penalties to a landlord if found in violation of the CDC or the governor's executive order? Let's take the CDC order first. What are the penalties?
So I would say that in terms of the CDC order, the CDC order doesn't outline specific penalties. I'm not aware of specific penalties to the CDC order. However, this is part of the reason why we say you should go to court, is that if a tenant given a declaration to a landlord and the landlord files for rent anyway, for example, then tenant first needs to be at court, have proof that they actually gave that declaration. So for example, if one was able to, if one hand deliver it, I recommend someone to have a receipt that shows, hey, I gave this to you, or at least if one's going to mail it, have some type of receipt, either a certificate of mailing or certified mailing receipt that shows that one mailed it to the landlord to give them notice of that declaration, and to present it to the judge and say, hey, I gave notice to the landlord that I qualify for the CDC declaration, that I given that declaration, I'm income eligible and I'm going to use my very best effort, and my landlord did this anyway. That is information that the judge needs to know, so that in making a determination of the fact, the judge can say, hey, the CDC order applies, and therefore I'm going to reserve judgment. Therefore, the landlord cannot act on it. Now, that's a little bit different. Say, for example, a landlord tries to ignore all that and still try to remove a tenant from the property. That's what we call like a self-help eviction or an illegal eviction, because as I said earlier, an eviction is a process that requires a court order. One cannot simply just take a person out of a place by brutal means. That is illegal. And if one is in that situation, they should call the police regarding this illegal removal, because technically the landlord's trespassing. And then with a police report, go to the nearest district court commissioner, where they may be able to file charges against the landlord for trying to illegally remove them from the property.
Right, and just to also include the governor's order. The governor's order doesn't create any additional prohibitions on landlords doing self-help evictions, but as Mr. Niven said, in order for an eviction to be done legally, there has to be a court order and it has to be executed by the sheriff. And there are criminal penalties and civil penalties for illegal evictions. Moreover, there's nothing in the governor's order that prevents your landlord from filing anything. What it prevents is a judgment from being entered. And so certainly your landlord can file actions against you. You may have to go to court for them, but as long as you qualify under the governor's order and a court determines that you qualify for the defense, a judgment can't be entered, or judgment is being reserved until the expiration of the emergency period, which means that until the expiration of the emergency period, no eviction can be legally done. And any eviction that would be done would be a self-help eviction, which would be something that could, like I said, incur both criminal and civil liability on the part of the landlord.
And also, I want to add one more thing. This is back to our prior point about resources, is that this is an ever-changing environment, and different localities are releasing different sums of money to go towards eviction prevention. And so I would say that if one was denied for eviction prevention funds over the summertime, I will highly encourage you to check again, because as localities are reformulating what money they have available to different purposes, it may become available maybe under a different name or a different program. But I know for example, Baltimore City some of the eviction funds from early summer are now going toward eviction prevention. And so while it's under different eligibility rules, it's going to be a different process, but there's still money available for residents who need that type of help to prevent an eviction.
I'm just going to add one caveat to what you said, Douglas, as far as the CDC order. The CDC order does, I believe, warn that there's a criminal penalty for violation of the order. The question, as in all these orders, is whether or not the police or the state's attorney's office will enforce the potential penalties for violation. And I believe those violations are up to $100,000 in fine and up to 1 year in jail. Let's see. Yeah. Here's a question. If you are unlawfully terminated during the pandemic, are you eligible for any of the eviction preventions that we're talking about?
Sure. So speaking just for the governor's order, it has to do with certain kinds of loss of income due to COVID or the surrounding circumstances. And if there is an allegation that the termination is illegal or the termination is in violation of state or federal employment law, I would suggest, first of all, and I'm going to sound like a broken record, in a complex case like that, contact a legal services professional as soon as possible, because that's going to be a very factually intensive inquiry. Nonetheless, I could see a circumstance in which that absolutely would still qualify under the governor's order, because again, the standard is through documentation or other objectively verifiable means. So I don't want to say anything that would cause a person to think that because they're contesting the validity of their employment termination, that they're not entitled to these defenses. And again, that's something where in these instances, contact the legal services provider just to talk through that, because that is a complex interrelated thing. I would sincerely hope that a court does not simply say that because you're contesting this in federal court, you're contesting this to the EEOC or whatever, that you're that you can't raise these defenses and I'm not going to consider them. But again, certainly if that is an issue you're facing, contact your local legal services provider and be sure to have all the documentation, because that does sound like a real complex issue.
The final question that we have is sort of a variation on the question I just asked. And that is, say an applicant can't prove that their rent arrearage is COVID-19 related. Do any of the affirmative defenses that we've been discussing this evening potentially apply to them?
I would say that in that situation, one's best bet would be the CDC ordinance, a CDC order, because the purpose of the CDC order is that we don't want people evicted because people are forcibly displaced out of their homes. You increase the risk of a COVID-19 infection. And what we're trying to do right now is to lower the incidence of infections in the country. So the CDC, arguably the CDC has much more flexibility than the governor's order in protecting a person from an eviction. Now the declaration provides that there will be, the tenant will provide as best as possible for rent. However, the purpose of the CDC order is broader than that. And so I think an argument may be made, and again, as we said before, one should speak to a lawyer about that situation, but it is I think the CDC more than likely, especially more so than the governor, will give one the ability to raise that argument as a defense.
Right,
So
and
it is now it's now exactly 7 o'clock. This has been a really spirited discussion, and I know that Dan, you had some other things to say. Won't we let you finish it if you can do that in about 30 seconds?
You ask a lawyer to talk in 30 seconds, I don't know. But I would simply say that to piggyback off what Douglas said is just because it doesn't seem immediately like your loss of income is due to COVID doesn't mean that it truly wasn't, and doesn't mean that there's not an explanation that makes it clear that COVID played a factor into it. You know, I interpret these rules to be very broad, both in the sense of prohibiting evictions or limiting evictions for public health related reasons, and also because of recognition that COVID really threw everything through a loop. So even if you are fairly, have some concerns that maybe your loss of employment or loss of income wasn't, I would still recommend talking to an attorney about that, because, in those conversations, I think a lot of different ways of looking at things can come out.
So thank you, gentlemen. Thank you to audience. With that, this concludes the Attorney General's COVID-19 Access to Justice Task Force Town Hall meeting on preventing eviction in the age of COVID-19. And again, I'll just leave you with this. Please go to court. Please encourage those that you know that are experiencing these problems to go to court. And please encourage folk or reach out to the legal providers or the legal resource providers that we have referred to. There are others. This list that we gave you is one that is statewide, and in each particular jurisdiction, there may be additional resources that are available. And we're all trying to work together on this because we know of the magnitude of the problem. And so I thank you again, and good night.
Okay,